Good afternoon, everyone, and it is a pleasure to reconvene the Standing Committee on Justice and Human Rights as we continue our study on mental health support for jurors. We have the pleasure today of being joined from Medicine Hat by Ms. Shauna Jobagi, who is a Deputy Clerk of the Court of Queen's Bench. Welcome, Ms. Jobagi.
Thank you.
And Ms. Dora Newcomb, who is representing also the Alberta Juror Support Program, who's joining us from Edmonton. Welcome, Ms. Newcomb.
Thank you.
And so, ladies, what we're going to do is hear from you, about 8 minutes for the two of you, and then what we really want to do is ask you questions. So we're going to start with the questions as soon as you finished your opening statements. And ladies, the floor is yours. I'm not sure who's starting.
I will start. Good afternoon, Mr. Chair and honourable members. Thank you for the opportunity to present this afternoon on behalf of Alberta Justice. As a bit of my background, I have been employed with Alberta Justice for 35 years. I have been part of the process of summonsing jurors, clerking the jury trial, clerking the selection, scheduling the jury trials, and most recently I was the team lead in implementing the Alberta Juror Support Program. Alberta was concerned about jurors years ago, both from the effect of toxic evidence and the effect of being in a very confrontational jury room, as most jurors come with no experience with regard to either. In fact, I still have the mental health package that we used in our jurisdiction dated 2008. Each court in Alberta was providing juror counseling assistance in their own unique way. However, there was no unified approach. Our concern was a result of our own experiences, which was supported by the following research. In 2009, Madam Justice Elizabeth Hughes and her team produced a report wherein one of the recommendations was to implement a juror support program as a result of her research in the field. Justice Hughes' research included references to the study by the University of Leicester in the United Kingdom called Vicarious Traumatization as a Consequence of Jury Service, which includes earlier studies from Canada, United States, and New Zealand. This study revealed that for the more vulnerable candidates, jury duty can lead to severe stress or post-traumatic stress disorder, or what the researchers referred to as vicarious traumatization. The finding found that some 23% of the jurors reported dealing with traumatic events, 5% reported that they had responded with intense fear, helplessness, or horror. One juror was diagnosed with post-traumatic stress disorder. She references literature from the Stress and the Canadian Criminal Trial Jury by Sanjeev Anand and Heather Manwater, which includes American case studies, wherein it concludes that if juries are to continue to play a role in the administration of criminal justice, the impact of trials on jurors cannot continue to be largely ignored. Her research identifies the program already implemented in Queensland, Australia, where their Jury Act indicates a former member of a jury may disclose jury information to a health professional who is treating the former member in relation to issues arising out of the former member's service on the jury. As a result of this research, counseling had been recognized as a necessary and important part of our system to support jurors on all criminal trials, notwithstanding the nature. As you've heard in your recent committee meetings, not only can the trial evidence impact a juror, but what happens in the jury room itself may also affect a juror's emotional health. The report made 4 recommendations: to provide juror counseling, to update our current handout mailed to prospective jurors regarding the process, to create one consistent general information sheet to be provided to the selected jurors in all Alberta locations, and recommendations regarding jury comfort, increase in fees, reimbursement for lost wages, escorts, etc. Therefore, to implement the recommendation for a juror support program, the team developed a process to ensure all jurors who require assistance can access it. The program information is provided to all jurors regardless of subject matter, and that the same service is being offered consistently province-wide. The judiciary can now rely on court administration to ensure this practice is being followed, no matter which jurisdiction they may be sitting in. Justice Hughes also recommended that jurors could access this counseling at any time after the commencement of trial, including mid-trial. However, the sessions had to be focused on emotional issues and not on the evidence. Through the procurement process, an invitation to tender was circulated wherein Chappelle was the successful service provider. The team had recommended 4 sessions be offered per juror to be utilized within 2 months of the conclusion of the trial, with a clause added that should the counselor determine more sessions were required, an application for an extension could be submitted to our department for consideration. This figure was a result of consultations with our Chappelle contacts, Dora Newcomb, who is joining us, and Claude Bork, and Madam Justice Hughes, through Corinne Jameson, our Court of Queen's Bench Executive Director here in Alberta. Chappelle drafted 2 handouts to be provided to jurors at the beginning of the trial, providing information regarding the impact of a court case and another on how to cope now that a difficult court case has concluded, which addresses their contact information. Jurors can access the toll-free number provided on the handout, which will connect them directly with a counselor. As a side note, it's important to mention that some of our judiciary do take the time to meet with the jury panel in the jury room after the trial has concluded, where it's appropriate, and at that time also reminds them of our counseling offer. In Alberta, for a 1-year period, September 2015 to August 2016, 68 jury trials were conducted, which would impact approximately 816 Albertans, and 7 had contacted Chappelle for counseling. Thank you, that's my presentation.
Thank you, Ms. Newcomb.
Members, thank you for this opportunity to appear before the committee this afternoon to talk about an important subject, the mental health support for Canadian jurors. At Morneau Chappelle, we're proud of the work that we've done with our provincial partners and pleased to see that this committee take an active interest in ensuring jurors are provided with high-quality support, especially after challenging and graphic trials. As a leader in the mental health field and mental health solutions since 1979, we have experience and expertise in helping individuals and their families deal with a range of traumatic events. But it was through our partnership with Alberta Justice and Ms. Jabagi and her team, we were able to start the dialogue around support for jurors following the research that had been done by Justice Madam Hughes. It's really important that we look at the impact of the trial on a juror. I don't believe that many times people understand really what jury members go through. They're getting called to do their civic duty, which is quite honorable, but in part of being part of a jury, they don't really know what they're going to be in for. And as a result, what may happen is that they're exposed to the graphic information, as you've heard during your earlier hearings, and become higher risk of longer-term adverse experiences. And when we started having these discussions with Alberta Justice, it really wasn't clear about all of the nature of the impacts, and there wasn't a clear blueprint or outline regarding the best practices, and so we really were on the cutting and leading edge of this whole initiative. What we've been able to develop, and I need to point out that this was a long journey to get to this point of launching this program, but because we really wanted to do our due diligence, whether that would be from Morneau Chappelle or Alberta Justice team, to look at all the key issues. But we have a program that is available to support jurors right from the very beginning, because they're given resource information to help them prepare for what they might experience. Also, they have access to counseling support during and after the trial, because we recognize that when jurors are coming to participate in a jury trial, they may have challenges already in their lives. And so that can also impact them and add additional stress during that whole jury and trial process. And it's not just for the juror. We also have to understand that when one individual is participating in a jury, it also has an impact on the family as well. We looked at offering the counseling, has been mentioned, 4 sessions of counseling, either in person or via telephone counseling. So that will allow people so they don't have to travel to access the counseling support. But we also know that we can offer extensions to individuals should they need additional counseling support. And we also recognize the need for the involvement of family members. And so we also can offer an extension or include family members, typically would be the spouse or partner of a jury member, as part of the counseling process. The programs provide that clinical support, but we're very focused on ensuring the integrity of the court process. So should a jury member access during the trial, the boundaries and parameters of what can be discussed during the counseling sessions is clearly laid out. In closing, let me thank you for giving both of us this opportunity today to discuss this juror support program. It's a program that we're both very passionate about, and I would be happy to answer any questions. Thank you.
Thank you very much to both of you for your testimony. So now, although it's, you're not in the room with us, we're going to be moving around the table for questions, and we're going to start with Mr. Liepert.
Thank you. Thank you both. I just have a couple of clarification questions. So if I understood correctly, Alberta Justice has a contract then with, is it Morneau Shepell, to provide these services? Is that the way it works?
Thank you for your question, and yes, you are correct.
Okay.
We went through formal RFP, request for proposal process, and we were awarded the contract.
And I'd like, can you tell us in rough figures how much that is? And the reason I'm asking the question is I'm trying to get at what roughly the cost is to Alberta Justice, and if there are additional costs beyond the contract with Morneau Shepell, just so that if the committee has an idea in Alberta what it costs, then that gives us a sense of what it might cost for a national program.
Mr. Chair, I'd like to respond to Mr. Liepert.
Yes, of course.
There are statistics regarding the cost. In the contract, it was negotiated, the hourly cost was $140 an hour. In your next session, Claude Bourque will be appearing on behalf of Morneau Shepell, and he will have more statistics as far as the actual dollar.
Okay.
Yeah.
But does that, are there other costs that Alberta Justice absorbs in this program, or is it sort of a totally contracted out initiative?
Right, it's totally contracted out initiative.
Okay.
The only other costs are not related to the program, but regarding the juror expenses and fees.
No,
That's part of our legislation.
No, I'm talking about the counseling part of it. So Morneau Shepell does all of the counseling on behalf of the Alberta government. Okay.
Correct.
You mentioned a couple of numbers at the beginning of your presentation. What kind of a tracking mechanism do you have in place that would determine the success or non-success of the program? I'd just like to know a little bit more about how you determine whether or not it's money well spent, if you might.
Dora, do you have a response?
Mr. Chair, I'd like to respond to that question. We do offer and provide statistical reporting back to the Alberta Justice team who is managing the program. Part of our counseling programs is always to look at asking the client for their to complete a satisfaction survey to ensure that the services that are provided are adequately meeting the needs. So that quality assurance piece is is a standard part of our clinical process as well. And if I can also add to the previous response, the costs to administer the program are included. So the overall administration, the support, that is all part of the program that we offer to Alberta Justice.
So without getting into privacy issues, is there an ability for you to provide this committee in some sort of a report that would kind of outline how you do the follow-up and the measurements and that sort of thing? Is that fair to ask, Mr. Chair, if you could provide something to the committee that would give us a sense of how it's working and what parts of it is working?
I think, Ms. Newcomb, that he's asking for the standard form that you ask the juror to complete to determine their satisfaction in blank, so it wouldn't have privacy issues?
Yes.
Well, that
Thank
plus...
you, Mr. Chair. I will.
That plus, Mr. Chair, though, if you've got something that would be kind of a summarization of what the clients have responded to you, do you provide that on sort of an annual basis to Alberta Justice?
We actually provide a statistical report on a semi-annual and annual basis, which outlines the number of individuals who've accessed the program. I would be happy to take your request away and work with Ms. Jabagi to look at providing those statistics, as well as the satisfaction survey, the feedback mechanism that we use with our clients.
I would appreciate that. Thank you.
You still have another minute, Mr. I didn't want to cut you off. I just
Go ahead. No,
Okay, perfect. But thank you. So just for clarity, I fully understand for confidentiality reasons, you don't have the right to choose to provide it. It's the Alberta Ministry that would make that determination. So if you could work with them, that would be wonderful.
Yes. Thank you.
Thank you very much. Thank you very much, Mr. Fraser.
Mr. McKinnon is next, actually.
Oh, Mr. McKinnon is going to. Okay, Mr. McKinnon.
Thanks, Chair. I believe my question is for Ms. Newcomb. I'm trying to get a sense of how much counseling is available. I have previous information that said counseling can be accessed by jurors during a trial or up to 2 months after the conclusion of a case. And I think you indicated that they get 4 sessions. Is that just standard, or is it as long as they need?
Thank you. I'd be happy to answer that question. They do start off, the program parameters are targeting 4 sessions of counseling. Typically, the period of time in which the jury member can access is up to 2 months following the conclusion of the trial. However, should one particular individual require additional sessions of support with approval, we can provide that as well.
So if they think they're okay, but 6 months later they say, I've got these issues that I have to work through, is that too late? Can they still get into the program after, say, 6 months?
I'd be happy to answer that question. We haven't, as far as I know, we haven't had individuals who have accessed or requested access for support after 6 months, but I believe that the agreement that we have with the Alberta Justice team would be to look at those individuals and consult and present the request for additional support without necessarily revealing the name of the individual juror to ensure confidentiality. So we would work with Ms. Jabagi and her team to ensure that that member gets the support that they need.
So the 4 sessions, is that just a number for costing purposes, sort of an estimate of what you might need? Or is, I guess what I'm wondering is how many, what is the normal amount of sessions that people might need? Is 4 enough, or do they generally need more? And how much more if they do?
When we were working with the Alberta Justice team, we were looking for literature or research that really gave a guideline in terms of the amount of support that would be needed for someone who had been part of a jury trial. And that data just didn't exist. And individuals, some individuals may be coping better following a trial than others. And so we really started by...
What is your experience with the service you're offering? How many people, how many sessions are typically needed?
At this point in time, when we reviewed the statistics, on average, it's been 3 sessions of counseling per individual juror.
Okay. Thank you very much.
Thank you.
I'd like to move on to Ms. Jabagi. I mean, it sounds like from the testimony I've heard and the information I've already seen that Alberta is doing a whole lot of things right. You mentioned things like, of course, counseling. Do you do pre-trial counseling? So, you know, you have a brochure that says what's available, but do you give any kind of a heads up to the jurors that says, you know, hold on to your hat because this was going to be a rough one, or you give them some kind of an indication that you know, to be aware of the issues they might encounter?
Mr. Chair, I'd like to address Mr. McKinnon. Yes. In Alberta, as you have heard from some of your previous witnesses in previous meetings, they are not given any notification prior to the trial as to what they are about to encounter, other than they're given a handout with their jury summons that talks about the process, but it doesn't give them any indication as to what the trial is about. At the very beginning, when they appear for their prospective selection, most often the justice will address the panel then, and if they feel it's appropriate, they will provide some details about what they might expect in this particular case.
In terms of receiving counseling during the trial, there are, of course, legal issues there. Have you found any difficulties around those issues, and would you foresee a need for adjustments to be made to the criminal law to allow better access to counseling during the trial and after the trial?
Well, as you heard from your previous witnesses, the deliberations are just as hard, or even what happens in that jury room is just as hard on them as the evidence itself. And I think that is why Justice Hughes made the recommendation to offer counseling mid-trial, because of what happens in that room that none of us are really privy to. Does that answer your question?
I guess I'm wondering about the legal constraints that people have about talking about what they're encountering. I guess they can't talk about the deliberations. They can't talk about the data, but it's going to be hard to talk to a counselor with talking around the issues they're dealing with. I'm wondering if they have enough scope in the current law to do what they need to do with counseling. And if not, I'm wondering if there's any changes to the law that you might be able to recommend. I realize that's a big question, so.
I think if you might have a. I think just to make it more precise, I think basically in your opening remarks you spoke to Australia's law where there was an exception for mental health professionals for jury disclosure. And I think what Mr. McKinnon is asking you is, would that type of an exception or a similar type of an exception be something you'd ask us to consider in our criminal code?
Yes.
A very clear, short answer. Thank you very much. Mr. McGregor.
Thank you very much, Mr. Chair. I'm very glad to hear that clear answer because, I was going to sort of follow along that same line of questioning from Mr. McKinnon. There is that section of the criminal code that allows for a judge to provide supports for jurors who have disabilities. And, it could be very easy for this committee to make a recommendation that maybe an additional section be added to the criminal code that allows for mental health supports to be provided. So glad to hear that could be a possibility for us. Ms. Jobagi, I'm curious because some of the testimony we've heard at this committee is that there are concerns that our justice system and the supports for it could turn into a bit of a patchwork quilt, where jurors in one province are eligible for some great support and others have nothing at all. Does Alberta Justice, have you had any inquiries from other provincial governments, officials in other justice programs, inquiring about the strengths of your program, or is there some curiosity? Is there anything you can tell this committee about that, inquiries from other provincial governments?
Yes, Mr. Chair, I'd like to address Mr. McGregor. I have been contacted by Ontario first. That was the first contact. The second contact was Saskatchewan. The third contact was the Yukon. I was told British Columbia was reaching out, but I have not been contacted by British Columbia yet.
Thank you. And in terms of what this committee can come forward with in recommendations, we've had former jurors talk about establishing a national standard for jurors. So, from your viewpoint as being really integral to how the Alberta Juror Support Program works, what other roles would you like to see or supports from the federal government? Is it more the Minister of Justice coordinating with her provincial counterparts, or is it something like what we did with our legal aid study, where we've made recommendations that the federal government be more involved in providing financial resources? Anything you can elaborate for us that would help us make those very clear recommendations to the federal Minister of Justice?
Like I said, I have listened to a couple of your committee meetings. All those comments were very accurate. And the recommendations, I was making notes as they were speaking. Their recommendations are very accurate as well as what they would like to see included in the program. Just because Alberta launched first doesn't mean that we have it right. And so some of the things that they were recommending are excellent ideas to be incorporated. And I think it would be beneficial for it to be the same Canada-wide. But I must be careful that I'm speaking personally and not on behalf of Alberta Justice.
Yep, absolutely. And Ms. Newcomb, just from your position with the company and the expert services that you provide, what's your experience been with other, provincial jurisdictions? If you can elaborate a little bit more on that, and if you have any thoughts on the suggestions for a federal role in this, if there's anything that you can add that you think might be helpful to us in our deliberations.
Thank you, Mr. I'd be happy to answer your question. I'm truly very proud of the work that has been done to, number one, recognize the impact of trials on jury members. And it appears that this is something that is not exclusive to just Alberta. So perhaps that we should be looking at a broader scope of supports for all citizens. Again, I'll speak on behalf of myself personally. It just seems to make sense that what is being done in one part of the country perhaps should be replicated across the country. On behalf of the organization, Morneau Shepell, we do have experience working with individuals that have experienced a range of traumatic events, whether it be natural disasters or different kinds of events, and recognizing that the experience of a jury member is very similar to those same types of post-traumatic stress that other individuals experience. So perhaps we need to recognize that traumatic events don't always look like a black and white type of a situation. And I think with these discussions we're having, we're really broadening our horizons as to what people are experiencing these days and how it can impact them.
Yeah, I mean, I've made mention of the fact before that, I've met with a variety of first responders in my job as Member of Parliament, and, these are trained professionals, and jurors are essentially plucked from civilian life and thrust into this situation. I was just wondering if either of you could comment. My colleagues and I were discussing further, we're in amazement that a study like this hasn't been completed before, and that jurors have been overlooked this long. I'm curious, why do you think that is? Why have we taken so long to recognize the incredibly important service of jurors?
Mr. Chair, I would like to respond to Mr. McGregor. Some of the reports have indicated that there's a great deal of inertia in the system and a resistance to change. Well, it's worked for hundreds of years. Why should we alter it? But there's been an increasing awareness and sensitivities, and that we know a lot more about human processes and behaviors now than we have in years gone by.
Mr. Chair, I'm
And
good
if
with
I-
that. Thank you. Oh, sorry.
Add something?
Yeah.
If I can, Mr. Chair, if I can add a comment to Mr. McGregor's question, I think we now have a greater appreciation and understanding about mental health issues in general. And we are recognizing that people who have worked in certain fields like first responders, just because they have chosen to work in those fields doesn't mean that they are immune to the impact of dealing with very difficult situations. And so I think now as a society, we have a greater understanding that people can be exposed to certain types of situations, whether they asked to participate in those events or not, and it can have an impact. So I think it's all part of the dialogue that we have been having nationally and globally around mental health in general. And maybe perhaps also because of some of the recent court cases and trials that have been more graphic or higher profile, we've also see that as well.
Thank you.
Thank you.
Mr. Fraser?
Thank you, Mr. Chair. Thanks both very much for attending today and the good information you've provided. Just following up on that last point, and Ms. Jogaby, maybe you can assist as well, but Ms. Newcomb, you were just saying about high-profile cases or perhaps particularly gruesome cases. I wonder if there is, post-trial, any kind of heightened awareness of the trauma that some of the jurors may have faced and the requirement for counseling be made aware to them in a different way. Are all cases treated the same, or is there heightened awareness, sort of, if there is a particular case that would perhaps more likely lead to somebody having mental distress? I think we lost the audio there of Ms. Jogaby.
Can you hear me okay now?
Yes.
The judiciary is the one who would be the most aware of the evidence and how it's impacting them. And by watching the jurors throughout the trial, I would say that more judiciary would be where one of my justices from Lethbridge said, where appropriate, they will go into the deliberation room at the end to speak to the jurors and remind them about the counseling. And I think it's because of what they're feeling. So if the judiciary is feeling it, you can imagine what these poor jurors are feeling. And so I wouldn't say it would be every case that they would make more awareness about the gruesome testimony and the impact. Case by case.
Okay. Can you walk me through, Ms. Jogaby, what would happen at the end of a trial, though, if it was, for example, a high-profile murder trial? Would there be an actual post-trial debriefing with all of the jurors and go through the information and ensure that they're aware of all of the services that are available to them? Because we've heard testimony that some of the jurors couldn't believe that basically the trial's over and out the door you walk, and there was no sort of kind of wrap-up in order to kind of put their minds at ease. What can you say about that?
Thank you, Mr. Chair. I'd like to address Mr. Fraser. Yes, they are correct. They are ushered out of the courtroom into their jury room. They pick up their backpacks and they go home. What we have been doing in certain jurisdictions is there will be a clerk that kind of oversees the jury, and she will meet with them at the end to remind them about the package. But there's no debriefing. And Ms. Newcomb and her team and my team, we talked about having, if it's a counselor or whoever, to come in at the very end for a debriefing. And your witnesses identified the need for that in these hearings. But it has not been implemented. Okay.
At the courthouse itself, Ms. Jogaby, we heard some testimony about there being concern for jurors' protection and safety and interacting with perhaps family members or people known to both the victim and the accused. Do you see any difficulty right now, the way it works in Alberta, and in particular with interaction in the parking lot or in break rooms or anything of the sort?
Thank you, Mr. Chair. I'd like to respond to Mr. Fraser. Yes, that is it could be an issue. So far in the province of Alberta, I have not been made aware of any altercations, but they certainly could go through security at the same time, so there's the possibility. In the larger centres, Calgary and Edmonton, there's not so much of a possibility of parking in the same parking lot or anything, where in the smaller centres that could happen, where they all use the same parking lot. And we just try to be more aware with the sheriff escorts and the clerk escorts and keeping the jury as protected as possible. They would use secure hallways, not the public hallways, but they still have to go through security.
Okay. Can you speak for a minute about jury compensation? I think you touched on in your opening remarks the fact that a review was done and perhaps jurors are compensated differently right now. How does it work in Alberta?
In Alberta, our jurors are compensated for a daily fee of $50 per day, and then their meals are reimbursed. Breakfast is $9.20, lunch $11.60, supper $20.75. Mileage at the rate of 0.505 per kilometer. Parking at $12.75 per day, unless they have a receipt. That's more. Babysitting is covered with receipt and daycare, but there is no coverage for lost wages.
In the post-trial, if somebody's to access counseling services and they live in a rural area and have to drive to the counseling services, they get their mileage paid for?
That has not been discussed yet. What Ms. Newcomb and I had discussed was for the rural areas, if they the counselor would go to them. Could you address that, please, Ms. Newcomb?
Happy to. And thank you for your question, Mr. Fraser. One of the things that we looked at when we looked at the counseling network is we recognize that some people might be in more rural areas, and so it would not be feasible for them to drive, an hour for counseling, or especially we have Alberta winter roads, that may make it more challenging. And so the counselor network that we're using, we do have counselors who people can see in person, make an appointment, see them in person, as well as telephone counseling. And so that is where the counselor would actually call the individual in their home or another place that's more convenient and proceed with the counseling appointment in that manner. So giving people that flexibility and option to meet their needs.
Okay. Do I have time for one more quick?
Yeah, take one more quick question.
Very quickly. With regard to the 4 counseling sessions that are provided, you said that they can basically ask for more if they need it. Who decides that? Who decides if they get it?
Thank you for your question, Mr. Fraser. They can ask for additional sessions, but it also could be the counselor themselves who are suggesting that this individual really needs more support. We have an agreement with the Alberta Justice team that we can provide additional counseling sessions. So we can go from 4 sessions up to 6 sessions. If there is a need for even more, then we would have a process to go back and talk to Ms. Jobagi and just indicate that we have a juror experiencing some additional challenges. Maybe it's something that's triggered in their personal life and they require 2 or 3 more sessions, and that's how the approval process would go without revealing names.
Thank you.
We'll go around and see, does anybody have any short questions? Mr. Nicholson?
Thank you very much, and thank you very much for your testimony here that you can and should be very proud of the fact that Alberta seems to be on what could be described as the cutting edge and moving forward and providing assistance and counseling to members of the jury. And you're ahead not just on the counseling, but even compensating with respect to a number of the expenses that jurors had. I think it sounds like yours is a little more complete than a number of the provinces. But let me just go back to that $50 a day. I mean, in an 8-hour day, that's a little over $6 an hour. Have you had people say to you, and you also mentioned the fact the strain these things are on families, have you ever had any feedback that this kind of payment adds to the stress that families go through? Because I would imagine there's not that many people that could support themselves on $6 and 33 cents an hour?
Yes, Mr. Chair, I'd like to respond to that. It definitely is an issue. In fact, the jurors can require to be excused because of financial hardship. And so we do have lots of applications prior to the selection to be excused because of financial hardship.
But as you say, most of them, when they're called to do their civic duty, they're there to do it with honor. It's too bad that is the case. Do you think part of the reason for this, and I actually suspect this myself, it's that inertia in our justice system that you talked about earlier, that maybe these prices were set in 1969 and nobody just has reviewed them since. Is that part of the issue, do you think?
I haven't really, I don't have permission on behalf of Alberta Justice to address that, but I can tell you that Justice Hughes' report does recommend an increase, and her recommendation was from $50 to at least $80.
And that was 2009, correct? That report?
Was the report in 2009 of Justice Hughes?
Yes, sir.
Thank you.
Almost 10 years ago.
10 years ago, and then it was already 80. Yeah.
There you go.
Okay, perfect. Mr. Yakino, you wanted a brief question?
Monsieur le Président, j'aurais une petite question qui porte sur les conditions d'exercice de jury.
The work conditions for jurors, do you believe that the requirements and exemptions should be different than what they are today with regard to long and complex trials like the mega trials which took place in Quebec?
Are you getting simultaneous translation when he's asking the question?
I understand the question. I wouldn't have the experience to answer that except on my personal opinion. The reasons for jurors to be excused today are already extensive, and they do encompass prior health conditions or mental health or any. There are several reasons to be excused. I don't see right now that needs to be enhanced. Does that answer your question?
Oui, thank you. Yes.
Thank you. Mr. McGregor, then Mr. Fraser, then Mr. Liebert.
Yeah, just a quick question for Ms. Jobagi. Now, you've informed this committee on the compensation that's offered to jurors, and you've talked a little bit about some of the stresses that they may experience from a significant drop in income. I'm just wondering, I know employment standards in each province allow for jury duty, and that it's not supposed to affect a person's employment, and that they're supposed to, at the end of their jury, to just slip right back into their job. Do you know of any cases where jurors have made complaints that they may have missed out on opportunities to advance in the work, miss out on skills training, just any kind of friction that they had with their employer as a result of their service? And I'm just wondering if Alberta Justice has any statistics on that.
No, there are no statistics available.
Okay.
I am aware in certain courthouses there has been complaints about having to go to work before the jury trial, coming in and doing the trial, going to work, similar to what your previous witnesses have testified. But I'm not aware of any statistics.
Fraser.
Thank you. Just quickly, Ms. Jobagi, sorry for mispronouncing your name earlier. I realize now it was incorrectly on my notice of meeting. But with regard to the jurors that are allowed to access the services for counseling, is that all jurors, even those who didn't see it all the way through to the final conclusion of the trial, if any jurors serve for any period of time?
Ms.
Yes.
Mr. Chair, I'd like to answer that question on behalf of Mr. Fraser. We have discussed those situations where a jury member might need to leave the trial for whatever reasons, does not see the is not participating through the full trial, and yes, we would consider them still being eligible for support. Those might be those special circumstances that we would discuss with the Alberta Justice team. I do recall that being one type of scenario that was discussed when we were looking at implementing the program, but I do not believe we've had any of those cases or situations occur.
All right, thanks.
Mr. Fraser, I would just like to add on behalf of Alberta Justice that you may be referring to those jurors where there are 14 and
Yes.
who get dismissed prior to the end of the trial. Yes, they would still be part of the program.
Okay, perfect. Yes, that was it. Mr. Liepert.
Just a quick question. Are all of the counseling services provided in-house at your firm, or do you find that there are situations where you have to go outside and contract, I guess, with medical professionals that you can't provide in-house?
Mr. Chair, I'd be happy to answer Mr. Liepert's question. Through Morneau Chappelle, we have a network of counselors that work for us and various contractual arrangements and agreements, from full-time salaried counselors to counselors that may be contracted, especially in smaller communities where they may not see that many clients. It might be a small hamlet where there aren't a lot of our customers. So there is the option, again, for individuals to access counseling in a method that works for them.
Okay, thank you.
If there's no further questions, we're going to now change panels. So I want to thank both of you ladies for your testimony. It was extremely helpful to all of us. We really learned an awful lot. And I congratulate Alberta on, as Mr. Nicholson said, really being avant-garde and a leader in this area in Canada. Thank you again so much for joining us. And
Thank you.
Thank you. And we'll adjourn for a second as we change panels. And I'd like to ask the people for the next panel to come up or join us by video conference. I will call this session back to order, and we're very honored to be joined by our next panel as we continue our study into mental health supports for jurors. We are joined from the Ontario Juror Support Program by Ms. Julia Bieleka, Manager Operational Support, Court Services Division, Ministry of the Attorney General. Welcome. And also by video conference from Toronto by Monsieur Claude Bourque. Monsieur Bourque, bienvenue.
Merci beaucoup. Good to be here.
And from Yukon Court Services, we've got Ms. Shannon Jensen, who is the Manager of Court Operations. Welcome, Ms. Jensen.
Thank you.
So we'll start with Ontario and then move to Yukon. So Ms. Bieleka, the floor is yours.
Very much. Good afternoon, members, and good afternoon, Chair. On behalf of the Province of Ontario and the Assistant Deputy Attorney General of Court Services Division, Ms. Sheila Bristow, I thank you for inviting me today to this important discussion about supports for jurors. My name is Julia Bieleka, and as the Chair mentioned, I am the Manager of the Operational Support Branch in the Court Services Division of Ontario's Ministry of the Attorney General. My area is responsible for providing policy guidance and support to the jury process in the province. In the time allotted to us today, I will provide first a high-level overview of the jury process in Ontario and the types of supports that are currently in place for jurors, including information about our Ontario's Juror Support Program, through which we provide counseling support for jurors. We believe that serving as a juror is an important public service. Juries are drawn from a broad cross-section of society, and because of that, can act as the conscience of the community. Those who participate often feel a heightened sense of community involvement because they have done their part to make sure justice has been served. So what does jury service look like in Ontario right now? Each year, approximately 500,000 questionnaires are mailed out across the province to prospective jurors, who are selected randomly from the most recent municipal voters lists. For people living in a First Nation community, other lists, such as band lists, are used. The juror questionnaire is used to determine whether a questionnaire recipient is eligible for jury duty. The questions in the questionnaire are based on eligibility requirements in Ontario's Juries Act. Upon completing and returning a juror questionnaire, if an individual is eligible for jury duty, he or she is placed on a jury roll. The following year, the individual may be randomly chosen from the roll to receive a summons to juror notice, which tells them that they must attend court on a specific date to be considered further for serving on the jury. They may also be chosen to serve as jurors at a coroner's inquest. If an individual is selected to sit on a jury for a trial or inquest, they will be advised of the estimated length as part of the selection process. Some jurors may be required for several days, others for several weeks. There's no set time limit. And informing the juror of the estimated length as part of the selection process helps them gain an understanding as to how long they may need to be away from family and work. In Ontario, there are a number of supports that we provide to jurors. First, to help potential jurors understand the jury process, Ontario created a jury duty video. It is called Jury Duty and You, and jurors can view the video when attending court for their summons, or they can view the video online on our website or on YouTube. We also currently provide financial support to jurors in certain circumstances. A juror may be paid for daily travel expenses, accommodation, or when serving on a trial for more than 10 days. There is currently no allowance for child or elder care at this time. The ministry is carefully considering how best to address this issue, as we understand that this may be a hardship for some jurors. The payment of jurors is made in accordance with the requirements of Ontario's Juries Act and Regulation 4 of the Administration of Justice Act. If a potential juror needs accommodation for a disability, they are encouraged to contact the court office as soon as they receive their summons. Every effort is made to provide necessary accommodations for people with disabilities to participate fully in the jury process. For example, a judge may allow an individual to use technical, personal, interpretive, or other support services to enable that person to serve on the jury. If a juror is receiving employment insurance benefits, they can attend jury duty and continue to receive their benefits. While jury duty is an important civic responsibility and can be rewarding, it can often be very difficult and stressful for jurors. The evidence and the testimony some jurors hear can be graphic. It can deal with very traumatic and violent crimes. In some cases, individuals have to take significant time away from their jobs, their families, and their lives. Talking to a qualified counselor can help jurors after a trial or inquest. The Juror Support Program, which Ontario established in partnership with Morneau Chapelle in January 2017, is available for Ontario's jurors at the conclusion of a trial or inquest. Jurors are able to receive up to 8 one-hour counseling sessions. A juror can speak with a counselor, toll-free, 24 hours, 7 days a week. Jurors can choose to receive this counseling in any manner they choose, in person, over the phone, by email, or video conference in English or French. They also receive disability accommodation when it is requested. There are no out-of-pocket expenses for jurors, and the program is completely confidential. Supporting jurors to perform their civic duty and making counseling more easily accessible for those who need it is very important to the ministry and to the province. Since the launch of our program in 2017, January, 24 jurors have contacted Morneau Chapelle for counseling. Ontario recognizes that the jury process may be challenging and stressful for some individuals. If a prospective juror has questions or if they require assistance in completing the jury questionnaire, they're able to contact ministry staff from our Provincial Jury Centre Monday to Friday. Once they're summoned, they can contact the courthouse that they have been summoned to before their court date. If an individual has concerns or difficulties once they arrive at the courthouse, they can speak to one of our court services officers or a jury clerk for assistance at any point in time. A juror can also make a request to the presiding judicial official to be excused from further participation in a trial or inquest if they feel that they cannot continue on in the process. The judge or coroner at that point will determine whether to grant that juror's request. Beyond the supports outlined above, a judicial officer may grant additional supports or compensation at their discretion. We do our best to ensure that concerns raised are responded to in a respectful and effective manner. I want to take this opportunity to reaffirm Ontario's commitment to ensuring a positive experience for jurors who serve on a trial or inquest. Thank you very much on behalf of the ministry and to all those who participate in the jury process each year in Ontario. We in Ontario are always open to considering feedback on how to improve the jury process. I look forward to answering any questions you may have today, and we look forward to receiving the recommendations of this committee in the future. Many thanks.
Thank you very much, Ms. Bilecka. Very much appreciated. And we'll move to Ms. Jensen. No, Ms. Bilecka was covering Ontario, she said. Sorry? Yeah. Ms. Jensen, the floor is yours.
Thank you, and good afternoon, Mr. Chair and the members of the committee. Thank you for the opportunity to present information on Yukon's new juror support program. To begin, I should note that our program is new only in the sense that Yukon just recently brought in a formal program this year. In fact, Yukon's courts have recognized the need for psychological support for jurors since at least 2001, when the presiding judge ordered that a group debriefing session be offered to jurors after a first-degree murder trial. This type of support was also subsequently arranged after other trials when the judiciary determined that the court proceedings may have been uncomfortable or difficult for jurors, and that remains a possibility to this day. Several years after that initial session, in anticipation of a number of upcoming murder trials, Yukon applied for and received federal funding to research the jury experience during such trials. As part of that research project, Yukon arranged for a voluntary group debriefing session led by 2 contracted psychologists to be held 24 to 72 hours after the conclusion of each of 3 trials. Some of the recommendations stemming from that study informed the development of the formal program started in 2017, including that printed materials be provided and that individual debriefing sessions be offered. In the development of Yukon's juror support program, we sought advice from our colleagues in both Alberta and Ontario, from whom you have already heard today. Our program is similar to theirs in that we offer a printed brochure to all jurors after each jury trial, which identifies common signs and symptoms of stress reactions, offers suggestions for self-care and ways that family and friends can help, and provides information on how to ask access professional counseling services on a voluntary and confidential basis. These services are provided by the same counseling service that is contracted by Yukon government to offer the Employee and Family Assistance Program, but jurors do not have to be Yukon government employees to access the juror support program. That counseling service is currently provided by Morneau Shepell. Each juror can access up to 4 counseling sessions free of charge to help them process their reactions to the trial. 2 additional sessions may also be offered at the discretion of the counselor, and more may also be approved if needed. Because jurors may experience immediate and/or delayed reactions, there is no time limit by which jurors must access the sessions. Counseling services are available in a number of different formats, including in person and by phone, and are completely confidential. However, because the counseling service provides statistics on the juror support program, we are able to tell what percentage of jurors are accessing this support. In the first few months of operation of our program, we have seen an uptake rate of about 17%, which indicates that there is interest in this service in the Yukon. In addition to the post-trial support program outlined just now, consideration has also been given to providing information to our jurors at the beginning of trials in order to help them prepare to process the material they will be exposed to. Yukon is therefore very interested in the work and recommendations of this committee in that regard. Thank you for the opportunity to speak. I would be happy to answer any questions committee members may have.
Thank you very much. Very much appreciated to hear both of those presentations. And now we'll move to questions from the panel to both Ontario and Yukon. So we'll start with Mr. Nicholson.
Thank you very much, and thank you very much for your testimony here. These are important breakthroughs, quite frankly, and steps forward here that both jurisdictions are now providing that counseling here, because as you know from the earlier testimony we've had before this committee, this is extremely important. Ms. Bieleka, you said that one of the things that are being considered is assisting people and compensating them for their child care and elder care. You said it's under consideration. How long has it been under consideration? Can you tell us?
Well, you know, we always evaluate our supports that we provide to jurors, and child care and elder care is something that comes up for certain individuals. So we have been considering that. I'm not definitively sure for how long. In the course of just doing our regular work, you know, we do try to improve and provide as many supports as we can to anyone who needs it. So that's one thing that has come up for certain people.
I certainly hope so. You know, I mean, yeah. Maybe you could tell me as well. When was the last time the compensation for people serving on juries was changed in Ontario? Do you know how long ago it was set?
I can tell you what the compensation is for jurors.
I know what the compensation is. Do you remember at what year or what time that was implemented? How long it's been the same? Maybe you could check into that for me,
yes.
Because I have a feeling that this has not been altered for a long, long time. And you probably have heard that people who serve on a jury in Ontario for the first 2 weeks get nothing, and then they get $40 a day if the trial lasts up to 2 months. And have you heard feedback from people or that this does put a strain on their family and their financial situation?
So compensation for jurors is not meant to replace it's not meant to be compensation, I guess, for their time in service as part of supporting the civic jury process. It is meant to simply assist them in meeting their obligations. You know, compensation is an important issue for Ontario, and
I agree with you. I think compensation is important, but I think also in the province of Ontario, there is no requirement that employers pay their employees who are serving on jury duty, is there?
That's right. There's no requirement at this time. There is a requirement for them to be offered time off to be allowed to participate, but employers are not expected or not required to compensate jurors for that time.
So you can see that could put quite a strain on there. We have no requirement for them to pay these people who serve on a jury, say, for 2 months, and we in the province of Ontario don't pay them anything for the first couple of weeks of the trial, and then $40 a day. I have a feeling that one's been kicking around for decades, but what do you think?
Individuals are able to request an excusal due to very many reasons. One of those could be financial hardship. So we do have instances where individuals who have been summoned for jury duty make those concerns known to the court and to the judicial official, and it's up to the judicial official's discretion to excuse from jury duty. So that is something that is available to jurors in our province.
I can imagine it would be. Mr. Chair, I wonder if you could find out when Ontario implemented those, quote, compensation guidelines.
We will ask Ms. Bielek if you could provide us that information once you've researched it. It would be very much appreciated, and we'll follow.
I'm sure it's part of the public record somewhere. But listen, thank you very much. I appreciate that, and thank you.
You guys have 2 more minutes. Did anybody else? Mr. Cooper?
Well, thank you to the witnesses. Ms. Balaka, just a couple of questions about Ontario's program in terms of the counseling services. You said that there are 8 3 one-hour sessions, and then there's a provision for additional sessions, and that's at the discretion of who? Is it the counselor or?
Our program offers 4 initial sessions. Then at the discretion of the counselor, the counselor is able to recommend an additional 4. And that is a total of 8 sessions. Beyond that, those cases are dealt on an individual basis. So to date, we have not received any requests for more sessions than 8. I think we had heard previously from Ms. Jobagi in Alberta. We don't see people using that many, but we as a province and in our agreement with Morneau Shepell are open to exploring further should it arise.
Right, and then the toll-free 24-hour service that can be done by phone or it can be done online. Is there a cap on that?
So that's all in the session. So essentially, the 8 sessions can be done in the manner that the juror chooses. So that means a person can do it by phone if they want to do another session by email, if they want to do another one in person. That'll be up to that individual to decide.
And you had mentioned that there have been 24 jurors that have approached Morneau Shepell for counseling services.
That's right.
That's out of approximately how many jurors over the last year or so that it's been in place?
Yes, it's been in place for about a year. Last year, there were around 7,000 jurors in the province of Ontario.
Okay, and I think in the testimony that had been provided in terms of the program in Alberta, it was said that on average it was about 3 counseling sessions. Is that consistent with what you're finding in Ontario amongst the 24 or so jurors who've accessed the program?
Yes, that's correct. I would say around 2 to 3 is the standard for most individuals.
Okay.
Yeah.
Thank you.
Ms. Khalid?
Thank you, Chair, and thank you to the witnesses for your testimony today. Ms. Bielek, so we just heard that there are about 7,000 jurors that go through the process per year, out of which there's a very small number that use the counseling services. Do you think that is because those counseling services are not required by the majority of jurors, or is it because there's a lack of I guess, a willingness or information for jurors to be able to know that service is out there for them?
I think counseling for anyone is extremely individual. I don't think that everyone needs counseling necessarily. I also think that it's a process to go through counseling. Anyone who's ever participated in counseling knows that extremely difficult, requires a lot of work on the part of the individual. So it really would vary by the person who wants that counseling. So I think that explains why some may choose to use that service, some may not. Some have other supports that they utilize within their communities, like family and friends, that they would rely on more than, let's say, a counselor specifically. And in terms of information to jurors, every single juror in our province receives the pamphlet. I brought it here today to leave with the committee, just for your reference in the future. They receive this pamphlet. Within the pamphlet itself, there's actually also a little pull-out card, because in Ontario we thought, sometimes the effects of this trauma can come about later down the line, and at that point in time the pamphlet may be somewhere and they're not able to find it. So we put together this wallet insert that they can take away with them and refer and have the number with them at any point in time. The information is available online as well. They can contact us. They can contact counselors directly by calling the toll-free number, but should a member of the public contact our ministry or any one of our courthouses about the service, they will be referred directly to Morneau.
And how long between the juror being relieved of their duty to basically taking those services, is there a cutoff as to when or up to when those services are available?
We in Ontario do not have a cutoff. Essentially, in developing this program in partnership with Morneau Shepell and using the good advice that we had from Alberta, we didn't want anyone to be disadvantaged. We didn't want anyone to be left behind, and we thought that we were not in a position to make a determination about when someone is no longer in need of our services. So we wanted it to be available for any juror at any time. Sometimes these things come up many, many months, years after the fact. So we wanted people to feel supported regardless of the time that they served.
Is there a formal debriefing process in Ontario for jurors who are just coming out of jury duty? By the court or by Morneau Shepell, if that's the case?
I wouldn't say the process is consistent across the province, and I don't think that there is a formal debrief process. I am aware that certain judicial officials, depending on the facts of the case and depending on what has happened during the course of that trial, may choose to address the jury. What happens at the end is the jurors are provided with this brochure and informed about the counseling services that are available to them.
Do you think a formal debrief process that is consistent, do you think that would be helpful for jurors in general?
Yes, I mean, I think from some of the information we've heard from former jurors that this committee has also heard in past sessions, I think jurors would feel supported by having a formal debrief at the end. That way they would feel, I guess, that there was some sort of closure, in a sense, to their experience.
The earlier panel, we heard that there is a kind of an exit survey, a satisfaction questionnaire that is administered to those that use the counseling services. Is there a similar process for Ontario as well, where there is a satisfaction questionnaire? And if there is, can we see what kind of questions are on that survey?
So, Claude, can you please take that one on behalf of Morneau?
Absolutely. Following, in the first session that takes place, there is a survey that is provided, so hard copy provided to the juror, and it is left to the juror to complete and to return that document. And so that would be brought together, and that would be delivered to the ministry in terms of the statistics.
And can we see, like, what are some of the questions that are asked on this survey?
The questions are in line with our employee assistance program, so it would be questions in terms of would there be lost days if you had not access to service, just in terms of the quality of the service starting from the first call through to the meeting with counselor as well.
Thank you.
Thank you. you very much, Ms. Cleed. So just the request is if we could, from Ontario, to get a copy of that survey, if it's possible, please. And any stats that you have that have compiled that are not confidential that you can share related to satisfaction levels. Same as we asked for Alberta. Thanks. So now we'll go to Mr. McGregor.
Thank you, Chair, and thank you to the witnesses for lending your expert testimony to our study today. We really appreciate the time you've made to appear before us. Ms. Bielek, if I can start with you. So you said during your testimony that at the conclusion of a trial, it's up to 8 counseling sessions. As we know, there are some trials which can go on for the better part of a year or even longer. Did you make mention of anything that might be available during the middle of a trial if a juror is, say, at the 5-month mark of a particularly gruesome murder trial and just feels the need that they have to get some counseling to help them process that the emotions that are going through their head?
We're very live to this issue, obviously, as you are as a committee. We wanted to balance, I guess, the legal obligations and understanding that this is something that would probably have to be up to the discretion of the judicial official in the courtroom. So I mentioned also in my testimony that at any point in time, jurors are able to make any of their concerns known to a judge. So how we have handled that issue in Ontario is if a juror does feel that they can't continue, they make that concern known to the judicial official. Now then it would be up to the judicial official to determine whether it's appropriate for that person to seek counseling, whether it's appropriate for that person to be excused and not continue. But should the judicial official sanction that person to receive counseling during the course of the trial, we would obviously allow them to access the service.
And as we can see from several provincial jurisdictions, interest in these kind of supports seems to be growing, which is a good thing. Yes. How are you aware of what the discussions are like between different provincial administrations? Like, are you aware of support from other provincial jurisdictions and how the Ontario program is working? And are you noticing like an increased interest? Like what's the level of interest with other provinces right now in their dealings with the province of Ontario?
I would definitely say we did get contacted by the individuals that I believe Shauna mentioned from the Yukon, from Alberta. We've had conversations. British Columbia has reached out to me. We have shared in every forum that we can that we as a province are willing. I'm willing to speak to anybody that needs advice and support in any of the other provinces. Mm-hmm. They're able to contact me at any point in time, and we're willing to share experience. We think that this is hugely important, hugely beneficial, mm-hmm. and we'd like to help other provinces mm-hmm.
Put it in place, I would say, yes. Mm-hmm. And as you might be aware, of course, we started this study, last week with some pretty heart-wrenching testimony from 4 jurors, not the least of which is Mr. Mark Ferrand, who I'm sure you're very well aware of in his role yes. in pushing for this. And, when I asked each of the jurors, they all lent their support to the idea of some sort of a national standard because they felt strongly, every single one of them, that a juror in, say, Prince Edward Island and a juror in British Columbia, they're both doing the same service to their community, and they should have that kind of a support system. And you have a sort of a privileged position here with your expertise in how the Ontario program works. But ultimately, we as a federal committee, we're aware of the provincial jurisdiction over the administration of justice. But I'm wondering, from your viewpoint, from the viewpoint of the Ministry of Attorney General, how do you feel about our inquiry into this and the possibility of a national standard? Do you have any recommendations you would like this committee to make, in particular to the Minister of Justice? I'm just wondering how that fits from your viewpoint.
I think we are very much looking forward to the outcomes of this committee's work. Mm-hmm. And implementing any additional information that the committee is willing to find and willing to share. Mm-hmm. We are looking forward to receiving any financial assistance and providing any further supports to jurors to help expand in any way, where appropriate, the program. In terms of a federal, I guess, national standard, I definitely agree with the comments made by former jurors that everybody needs some sort of support. And I would also say that it would be important for provinces to have flexibility to a certain extent to determine how best a national standard, if such a standard should exist, would make the most sense within that specific jurisdiction and for specific communities within those jurisdictions.
Thank you. And Ms. Jensen, just also from your viewpoint from Yukon, on the same question that I just posed, you know, in terms of what kind of recommendations this committee can make, and the previous testimony that we've had about a national standard, do you have any ideas that you would like to share with this committee in helping us reach those?
I think from Yukon's perspective, we're also very interested in the work of the committee and the recommendations that are expected. As my colleague in Ontario said, I would recommend that each jurisdiction be allowed a little bit of flexibility as to how to implement a standard. For example, I think one of the great features about the program that we have is the ability for the counselor to recommend more sessions if needed, right? Rather than just saying, okay, there's 4 or 8 or however many sessions and capping it at that. So I do think flexibility is important, but certainly the jurisdictions work together on any number of issues to do with justice, and I expect that this would be one of them as well.
Thank you.
Thank you very much. Mr. Seekand. Want to go first?
Yes. Thank you, Mr. President.
Okay, so Mr. Yakinos is going to take...
We'll be sharing our time.
Okay.
Thank you very much. With respect to this program, what are the strengths and weaknesses of this program? Can you highlight that? Because it's a fairly new program, less than a year or so.
Yes. I would say, in terms of strengths, I find some of the strengths of our program that we have no time limit, that we're willing to work with any requests that come forward through Morneau or through former jurors. We tried to leave it as flexible as we could to address anomalies, but meet some sort of baseline standard for everyone. So we had to obviously have some sort of structure, but we wanted to ensure that we're able to tailor as needed. Another strength, I think, is that it's available across the province and available in any manner that the juror chooses to access it. I think that's important because not everyone will have a need or a want to access counseling in the same way.
And I'm sure the program has been evaluated since it's been inaugurated. And what lessons have you learned from it?
I think the lesson we learned is that, when we were launching the program, we were concerned about the number of sessions. We were concerned around making sure that everyone has access to the service. And, I'm happy to report that we have not maxed the number of sessions, and we have not received any requests that we're not able to meet from an accommodation perspective or a language perspective.
So, interesting enough, you said earlier 7,000 trials and only 24 people have used in the last year. Is that correct?
7,000 jurors and
7,000 says that's it, and only 24 have used it.
Yes, that's
right. Is that
right.
because the jurors are not aware of it? Is that because they're shy, they feel intimidated, or what's the reason? Do you know? Is that part of your questioning process?
I think for these types of programs, it's not. I don't think a measure of success is necessarily usage, so to speak, because counseling is an individual thing for everybody. So, from my perspective, everyone has the option of using the service if they need it. But not everyone will want to go through the process of counseling following a trial. I think also we have to remember that because the program's only been there for a year, and we have, I guess, addressed and understood that mental health has come to the forefront more so now than ever before. I do expect that potentially in the future we will be getting more of an increased uptake.
And what do you foresee? Because I find the number is very low. If you had 7,000 jurors, I would expect the numbers would be close to 1,000 of how many people would be using the service. To only be 24, then there's got to be something that's not attractive to the jurors to come forward and to use this program and to use this service. So something has to be done in order to make it simpler for them to be able to adhere to it. Don't you agree?
I certainly hope that that's not the case, but we are definitely open to any feedback. We have not heard any concerns from jurors. We have not received any negative feedback from the community. So far, it has been quite positive. But of course, if there are any concerns or if people feel that there should be changes, we are an early program. It has only been a year, and as my colleague in Alberta mentioned, our main goal is to provide as much service as possible to jurors. So if there's anything that needs to be improved or could be improved, we welcome that feedback. We welcome the feedback from this committee also. Thank you for your question.
I've only got 2 minutes, so I'm going to go quite quickly. In your testimony, you mentioned that jurors are provided with some explanation of the length, duration, the parameters of what they're going to enter. Does that also include the graphic nature they're going to see of a high-profile trial, for example?
That is up to the discretion of the judicial official to determine how much, if any, information is going to be shared with those jurors at the commencement of trial.
Okay. And then you mentioned that jurors are provided 8 sessions, an hour each.
Yes, that's right.
Is there a limit on this if they require further sessions?
So there's no limit on it necessarily. It is a case-by-case basis. So if we had received information from Arnaud Chappelle indicating that somebody requires further support, we are willing to consider those circumstances and address accordingly.
On a case-by-case basis?
Yes. As I mentioned, the usage indicates that no one has even come close to that amount.
Okay. And the 24 individuals that you mentioned, were they all from the same trials?
No.
No. Okay. And then, thank you very much. I just have one quick question for Shannon. I think just following up on Mr. McGregor said about the level of service, and due to the remoteness of your court services, do you feel you get the same level or administer the same level of service to the jurors afterwards?
I think we do. In the Yukon, it is a very new program. We have actually only had one trial since we rolled this out. And from that trial, we know that 2 of the 12 jurors accessed the support. So like my colleagues in Alberta and Ontario, we're very much open to feedback and learning what we can do to provide even more support to jurors.
And just, was that by way of video conference or was that in person?
I do not know the method by which they access the sessions. I'm sorry.
The medium doesn't really matter. I was just curious. Thank you.
Thank you very much. We'll go to shorter questions. By the way, just from Ms. Jensen's perspective, there's also the same request I think we would make. If you do have, I know it's a very embryonic program, but if you do have any evaluation materials that you use, for people after they've had, counseling services or made use of the program, we'd appreciate seeing what you asked them and any stats that you may have, although, of course, it's only been one trial. By the way, I thought the other document that you provided explaining to jurors what the potential signs were of mental distress was excellent. and definitely goes to best practice. So, any Mr. Cooper?
Well, just one small question to Ms. Belaka. Just in terms of information that is provided to jurors about accessing services, you talked about the fact that they do receive a brochure that provides contact information for counseling and further information. Is anything else provided to jurors to make them aware about the programs and services that are available to them beyond the brochure?
We felt that it was timely. In terms of accessing the services, people will obviously be most live to their need either during the trial or immediately after. So what we do is provide them this information with the brochure, and the brochure doesn't just contain the contact information with the phone number, but it also provides, similar I think to Alberta and the Yukon, the impact of jury duty. So it outlines for them some of the things and signs and symptoms that they may experience as they go through, and then they can contact the service right away.
Are you leaving those for us?
Yes, I will. I will leave these for everybody.
One last question. It's very broad, but it could just give us some sort of orientation. I know the program, but what is exactly the consultation? What is exactly you tell people? Just to give us a brief info of what exactly you do as counseling. What does it entail?
Could you please clarify your question? What exactly the counseling entails?
Yes,
or?
I know for every individual will be different, and also whatever case will be different. But what are the repetitive tools that you guys use in communicating with the people that are calling on you to get some help?
Yes. So Claude, can you take that on behalf of Morneau Chappelle, please?
I can. So with regards to the session, the juror will be meeting with a master's prepared counselor. The support that we provide is one of a short-term focus, and so the request of that juror, we will be supporting them with their presenting needs. So not only will we be evaluating in that first session, we will be assessing in terms of what's required, but building a plan through the sessions that they would like to make use of.
Two questions that I'd like to ask Ms. Belaka. The first is, you made a conscious decision then not to offer counseling services automatically during trial the way Alberta did. And you voiced that you had to balance both legal concerns with the potential mental issues that jurors may face, and while being excused from a jury is available in jurisdictions, obviously that's a slightly different issue. Can you sort of talk to us about how you came to that decision, how you balanced the potential influence a counselor might have on a juror, or issues that might arise related to counseling during trial versus the potential impacts on jurors, and why Ontario came to that decision?
So we understood, I guess, that we weren't really in a position to make the decision for all jurors and for all judicial officials that everyone on the jury panel could access counseling during the course of the trial, because anything that happens in the courtroom is really up to the discretion of the judge. So we felt it was best to leave that decision there, and the judicial officials, of course, being aware that jurors can request excusal or request consideration on any number of grounds. So similar to any other grounds that they may request support from the judicial official about, this is just another one of those things that they may need as they go through the process. So that was the reason that we chose to go that route.
Thank you. A small supplementary on that. Would Ontario support, I obviously can't speak for Ontario, you probably can, this can only speak for yourself because you probably haven't even considered it in the ministry, but would you support an exception to jurors post-trial discussing with a mental health counselor elements of deliberation or information from the trial that they currently would be precluded from doing so, based on the Australian model?
That's a difficult question. I'm not sure if I'm in a position to answer that. Would I support the exclusion?
I mean, certain jurors have come forward that have recounted their experiences and talked about the difficulties they have even post-trial in counseling, being able to share some of the the details of what occurred that have caused the emotional problems that they've suffered from. And so given that Australia had it, given that it seems that the Alberta 2009 study recommended it, I was just wondering if Ontario had any position, or you had any personal, based on your knowledge, position.
I don't have a personal position. I think probably that question is best answered by a legal professional.
Fair enough. And one last question, bilingualism. So you said these services are available in both languages.
Yes.
How do you ensure that whoever's calling 24/7 has access to counseling services, for example, in Ontario and French?
Claude, if you could answer that one, that would be lovely.
Absolutely. So when calling into the line, there is the choice of selection for French or English, and so the caller is then able to speak in the language of their preference.
And you staffed it so that there's bilingual people answering that phone 24/7?
Absolutely, and I would say that there are a number of other languages that are staffed in there as well to ensure that it reflects.
And the counselors across Ontario, even in small communities, you're able to provide that counseling service in French?
At this point, we are able to deliver the support as required, and so I think the beauty of our net of counselors is that if there's a need to bring in other counselors in terms of a language issue, we're able to do that. But currently, we're staffed to be able to support both French and English, yes.
Thank you very much, Mr. Liepert.
If you dealt with this earlier, I apologize, but do you have a budget for this program for this year?
So this is completely funded at no additional cost to our ministry. It's within our current financial allocation.
But do you have sort of an internal estimate of what this program would cost? And so maybe a better way to phrase it would be, is it, from Morneau Shepell's standpoint, is it a charge as usage basis, or is it a blanket contract, or how does it work?
Mr. Bork, I don't know if you heard the question.
Could you repeat the question?
Yeah, the question to Mr. Liepert was, how is Morneau Shepell paid by Ontario? Is it on a per incident basis, per hour basis? What is the total cost per year to Ontario from Morneau Shepell for providing this service, is what he's asked.
Thank you. So similar to the Alberta program, the cost is on an hourly basis.
Yeah, so whatever demand there is for the services, you have an arrangement with Morneau Shepell that the services are provided and then billed back.
That is correct. So it's on a fee-for-service basis, so that the hours that are used will then allow that to move. Yes.
Okay. All right. I think it would be helpful if we sort of had an idea on an annual basis what this costs, because if we are going to come forward with a recommendation for standards, it would be helpful to have an idea of what the provinces are going to have to incur on a cost based on this. I'm sure in the scheme of things it's not very much, but if there was any way that we could get an estimate would be helpful.
Let me just ask, in Ontario, I'm sorry, in Alberta, I think they said it was $120 an hour. I can't remember. It was something in that 140 an hour. If we're saying it's on average three visits by juror, so that's 140 times 3, so it's 420 times 24 jurors. Are we then coming to the actual, close to that actual amount by doing that, or is there some other cost that we're missing?
Right.
You are correct with regards to the figures that you provided.
Okay.
So just that, I guess the reason maybe I'm asking this is if the pushback would be from provinces, I think we can safely say we're talking thousands of dollars, not millions of dollars. And I think that's an important ability for us to have to advance recommendations. So thank you.
Yeah. Any other questions, colleagues? If not, I want to thank very much the representatives of Ontario and the Yukon who came before us today. You were incredibly helpful. Thank you again, both provinces, province and territory, for being avant-garde and ahead of the curve on helping jurors in your jurisdiction. It's very much appreciated by the committee, and we'll definitely pay a lot of attention to what you said. Thanks.
Thank you.
Meeting adjourned.
Tuesday